Hi, and welcome to Faculty View from CWRU. My name is Katie Steiner. I'm a second-year law student here at Case, and I'm editor-in-chief of Volume 49 of the Case Western Reserve Journal of International Law. I'm here today with Professor Dalindyebo Shabalala, who is visiting assistant professor here at Case Law School, and also assistant professor of international economic law and intellectual property law at Maastricht University. Today, Professor Shabalala is here to share his insights on recent conversations within the international community on the subject of traditional knowledge. So before turning to the substance of those conversations, perhaps we should start by asking what is traditional knowledge, how is it defined, and what are some examples of traditional knowledge?
So traditional knowledge is essentially the knowledge generated by communities and indigenous peoples over generations that is transmitted orally or by other means. And that's the core definition. We usually also define it in opposition to intellectual property, traditional intellectual property, patents and copyright and trademarks, specifically because the knowledge itself usually isn't protectable by patents because it lacks novelty or inventive step, isn't protectable by copyright because it lacks originality, and isn't protectable by trademarks because it lacks, say, distinctiveness. And so, given those two elements, this knowledge by these communities suffers from leakage and from other issues such as misappropriation that have become, I think, increasingly concerning both to communities and to the international community.
And so what are some examples of traditional knowledge in the United States or in South America or in Africa, for example?
Well, so in the United States, we have an experience in this specifically that created a legislative response. So in the U.S., we have now the Indian Crafts Act, which protects Native American crafts from inauthentic claims around the source of the craft. So for a while, Indian artisans and handicrafts makers were suffering from a flood of essentially fakes, counterfeit claims around the source of Indian artifacts and crafts, and there was no way for them to get protection because of the way the knowledge was. They couldn't get copyright protection, they couldn't get trademark protection. It was really cultural theft of a sort. And so the legislative response was to go to the federal level and get the Indian Crafts Act passed. But of course, that only works in the U.S., right? It doesn't protect the native artisans from that misappropriation in Latin America, Africa, Europe, China, Japan. And that's also then the other problem that we need to deal with. You know, you see other examples such as the one that's most classic on neem and turmeric from India, where neem, which was developed and used as a healing agent in India for generations. When some people migrated to the U.S., they tried to patent it here, right? And of course, right, because the U.S. has a very low novelty standard in terms of how things can be patented here, especially around the fact that if it's not published outside the U.S., right, then it will pass novelty. They were able to get the patent. And only because we found an obscure, right, not we, but people found an obscure small text, were they able to get that patent invalidated. So you see that kind of misappropriation of the knowledge using the patent system or using the copyright system for these communities. And so there's both the domestic problem of getting domestic protection, but also the international problem of how do you prevent this kind of cross-border misappropriation, which is where really the need for an international solution arose.
Right. And so given the risks that traditional knowledge is subject to, what are some of the ways in which the international community has responded to provide legal protections for traditional knowledge, and specifically involving the World Intellectual Property Organization, the UN Specialized Agency? How has WIPO led efforts in order to create legal protections for traditional knowledge?
So WIPO has traditionally been a place where rights holders go to seek for vindication of their rights in the international arena. It did that with copyright, with the Berne Convention in the late 19th century, with patents with the Paris Convention in the late 19th century as well. And that was meant to solve exactly this kind of problem, where you had differing national systems for protection, but they wanted to harmonize and deal with the cross-border sort of misappropriation of their knowledge. Right? And so it seemed like a natural place for indigenous peoples and traditional communities to go to seek vindication of their rights to this intangible knowledge. And so in 1995, WIPO began to get involved in this, over 20 years now. And it has been a slow process, but WIPO has been really good at providing a basis for further national legislation by helping to define issues such as what should be the appropriate term of protection, right? And we've got a consensus that no, there shouldn't be as long a term of protection. Who should be the beneficiaries? It's helped to define who the communities and indigenous peoples are, who should be the beneficiaries. It's helped to define the issue of whether there should be exceptions and limitations. Again, the discussions at WIPO have helped to concretize this. And now we're at a stage where we really have negotiated text on the tables for protection of traditional knowledge, for protection of genetic resources, protection of folklore, right? And we're in the process of really hard negotiations between countries and between indigenous communities who are participating in this negotiation for really, I think, in a unique way. And it's progressing, we hope, nicely. And we've had a real nice sort of refreshing restart to this process in the past year with a new mandate to continue these negotiations.
Great. So, Professor Shabalala, on that note, the delegates from the WIPO member states met most recently in February of this year, 2016, to continue their negotiations on the legal instrument for the protection of traditional knowledge. How would you summarize the outcome of that conversation, and what is your forecast for the future discussions that will take place really in just a few weeks, beginning in May of this year?
So, I think the analogy has to be a musician who hasn't played an instrument for many years, and you come back, especially violin, and you realize it's out of tune, you're out of tune, you potentially are terrible at this, right? And so the discussions, especially in this initial period, were very difficult. I think one can point in particular to the difficulties that countries like Australia, New Zealand, the US have in representing both themselves, but also remaining in conflict with their indigenous groups. So in the U.S., there's still a significant difference between the Native American groups and the U.S. position, which is driven by the USPTO in particular. There's just a big gap. And so that's one of the things that really will need to be solved. The same thing with Australia and the Aboriginal peoples there, and New Zealand and the Maori. Those countries really are the ones where the barrier is, because there's a fundamental concern, which is, if they solve this intellectual property issue, or they try to address this intellectual property issue, will it implicate the broader claims to sovereignty that these groups have, these indigenous peoples have? And that's really the trust issue we have to deal with. That's really the technical issue that has to be addressed. Can you solve the claims around traditional knowledge and around traditional cultural expressions without implicating the broader claims to sovereignty of these communities and causing a bigger fight than we have to at the moment?
Yeah, absolutely. Big questions indeed. Well, Professor Shabalala, thank you so much for sharing your remarks and your insights on this topic, and thanks to everyone for tuning in.